ನಮಸ್ಕಾರ ಸರ್. ಕುಂಭಮೇಳ ಚೆನ್ನಾಗಿತ್ತು. ಇಲ್ಲ ಸರ್, ಎಲ್ಲಿ ನಮಗೆ ಅಷ್ಟು ನಡೆಯೋದಾಗಲ್ರಿ. ಇವೆಲ್ಲ ಹೆಂಗಲ್ಲ.
Tomorrow. Contempt.
What is that? Tomorrow, my lord, IFR suspension of sentence, my lord.
Tomorrow, next week.
Already the last.
Tuesday.
Please.
MFA, my lord, appeal filed with the insurance company.
Nale.
Climax have filed with the UP.
ಯಾವ ಸ್ಟೇಜ್ ಇದೆ ರೀ?
Tomorrow.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಫೈನಲ್ ಹಿಯರಿಂಗ್,
ಮೂರು ಮೇಲೆ.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
ಹಾ ಕೊಡಿ.
25ಕ್ಕೆ ಬರ್ತೈತಿ. 25ನೇ ತಾರೀಕು ಬರ್ತೈತಿ.
Yesterday one matter I have moved malas withdrawing the appeal malas that not listed today malas.
2:30 ಹಾಕಿದೆ. Withdrawal of appeal. 2:30 ಮಾಡ್ಬಿಡಿ.
ಇಲ್ಲ ನಾಳೆ ಪಾರ್ಟಿ ನಾಳೆ ಬರಕ್ಕೆ ಹೇಳಿದೀನಿ. ನಾಳೆ ಪ್ಲೀಸ್.
ಅದೇನ್ ಮ್ಯಾಟರ್? ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್?
Family court. Last date of
the divorce matter is recently I got the stay. I convinced him that then there is divorce is already granted by the family court. There is no fun in continuing the matter. They have agreed now. So I will be withdrawing it. The recent matter yesterday, before yesterday's matter.
Husband stay.
Husband's petition where the divorce is already granted.
Is RFA tomorrow? RFA tomorrow is.
RFA ಯಾವ್ದು?
RFA tomorrow ಇದೆ recalling. ನಾಳೆ ಇರಂಗಿಲ್ಲ. ನಾಡ್ದು ಇರಂಗಿಲ್ಲ.
Admission, ಏನ್ RF ಏನು?
ಅದು ಇದು DNP ಆಗಿದೆ, ರಿಕಾಲಿಂಗ್ ಹಾಕೊಂಡಿದ್ವಿ ಟುಮಾರೋ.
Page wise adjournment. Page number 6, serial number 25 and 26. Page number 7, 27 to 30. Page number 8, 31 to 30. Page number 9, 36 to 41.
My lord, serial number 36, my lord. A week's time granted.
You have informed the other side.
Yeah.
At request. Relist the matter. In the first week of March.
Published.
Yes.
Page number 10, serial number 42 to 47. Page number 11, serial number 48. Serial number 1, non-compliance of office objection.
My lords, I appear for the appellant's counsel, serial number 1, my lords.
Yes.
This is the same matter listed last week. Your lordships may recollect, we had to file an IA for continuation of delay, since we had reckoned the date from the date on which the IA for clarification was rejected. So we have now filed an IA for continuation. So the office objection may not survive.
Yes. So what is the main matter?
Because the main matter really revolves on a very narrow compass. The respondent's mother, my lords, was the owner of a parcel of property which was acquired for this Yermaris thermal plant in near Raichur. Now, one of the schemes, my lords, for the land losers was to give their kith and kin training, and if they are found to be satisfactory during training, to provide them employment in the thermal plant. Now, my lords, will find that the respondent was appointed as a trainee on 27th of March 2017, which my lords will find at Annexure C, page 43.
27/3/2017.
That's right, my lords, that's right.
Yes.
Now, if my lords were to see this, the communication sent to him, the terms of appointment were fairly clear. This was way back about, of course, 8 years ago. If I may just read out page 43, my lords.
Yes.
I'll just read below the Vishaya, my lords. Yermara Shakhotpanna Vidyut Yojanegagi, Raichur Talukina Chikkasugur Gramada so-and-so survey number, so-and-so ekre jaminu ಸ್ವಾಧೀನವಾಗಿದ್ದು ದಿನಾಂಕ 9/9/2016 ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ನಿಮ್ಮನ್ನು ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ನಿಗಮ ನಿಯಮದಲ್ಲಿ ಟ್ರೇನಿ ಗ್ರೇಡ್ ಡಿ ತರಬೇತಿ ಪಡೆಯಲು ಆಯ್ಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಈ ಆಯ್ಕೆಯು ಕೆಳಕಂಡ ಷರತ್ತುಗೊಳಪಟ್ಟಿರುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಸಿ ಕ್ಲಾಸ್ 3, my lords. ತರಬೇತಿಯ ಅವಧಿಯನ್ನು ಪೂರೈಸಿದ ನಂತರ ನಿಗಮದಲ್ಲಿ ಯಾವುದೇ ಹುದ್ದೆ ನೀಡುವ ಬದ್ಧತೆ ನಿಮ್ಮ ತೃಪ್ತಿಕರ ತರಬೇತಿ ಪೂರ್ಣಗೊಳಿಸುವುದರ ಮೇಲೆ ಅವಲಂಬಿಸಿರುತ್ತದೆ. So therefore, was not just completing the training, but the satisfactory completion of training. Then, Malas, he was appointed. Of course, our submission in the statement of objections is that he was not regularly attending even the training. If my lords were to, I'll take my lords through it at a relevant point in time. Even from 2017 up to 2020, he regularly kept himself absent. He did not complete the training at all. But where it came to an absolute, where we could not tolerate this anymore was, admittedly, during COVID, we had to issue him a show cause notice saying that you have completely remained absent. Therefore, please show cause why we should not terminate you even from a trainee grade D post. Because he filed his reply saying, of course, there was lockdown. I live in the neighboring state, Andhra Pradesh, in Kurnool. To travel during lockdown was impossible. And therefore, of course, eventually, my lords, his traineeship was terminated. My lords will find that at page 46, typed copy.
Was there any inquiry?
No, there was no inquiry. There was no inquiry. There was a show cause notice. We considered the show cause notice and issued this terminating was great. Of course, I understand he was only a trainee. Now, what the learned single judge has done, even without reading this, what the learned single judge has done, where we are possibly aggrieved by, if my lords were to see the impugned order at page 20 and 21.
Yes.
I just read para 7, my lords.
Yes.
Page 20. In my view, the reason for the unauthorized absence, that is the onset of the COVID pandemic, will have to be accepted in the present case, more so because the area in which the petitioner was residing was in the neighboring state which abuts the project area, and every time the petitioner had to enter, necessarily he had to be quarantined for 14 days, and similarly, when he went back to his home, he had to suffer another quarantine. In such a situation, the absence of the petitioner ought not to have been taken into consideration. Impugned orders therefore quashed. Respondents are directed to consider the case of the petitioner for regular appointment, just as been done in other cases, without reference to this period of unauthorized absence. This process of granting him regular appointment shall be completed within a period of 2 months. Now, Malaj, we are possibly okay with, if your lordship of the directors to take him back as a trainee, we are abiding by it. But what the learned single judge has done is to consider his case for regularization and regularly appoint him. As a trainee, we can take him back, but not as a regular. That's our only grievance, which is why we sought an IA for clarification, which came to be rejected.
Yes, just one clarification. As on
Yes.
the date of termination, he was still a trainee.
He was still a trainee, my lords. Our statement of objections, in fact, if my lords were to see, in fact, he has remained absent for more than 600 days between. But of course, unfortunately, our show cause notice doesn't say that. So I can't rely on something in my statement of objections. If possibly he was put on notice on why he remained absent, for the show cause notice relates to COVID. Now, he may have a legitimate explanation for that. Frankly, all of us were under duress during that time. But
Yes.
even before that, for 600 odd days, no explanation. But we may have to issue him a notice for that. So if that liberty is reserved, and rather than considering him for regular appointment, we'll continue him as a trainee if your lordship directs. But he'll still have to explain why he remained absent for even the previous period. That's all our limited grievances.
So correct. In so far as liberty for inquiry,
Yes.
now that order of termination has to go. So
Yes.
upon appearance of the other side, then that could be set aside and liberty reserved. As of now, we'll consider the limited prayer of reinstatement as a trainee.
Grateful. That's all.
Learned Senior Counsel appearing for the Sri Vikram Huligol, appearing for the Karnataka Power Corporation, submits that the release of the petitioner from his training assignment is ought to have been appreciated in the context of his continuous absence. It is further contended that even if the petition were to be allowed, at the best, the single judge ought to have passed a direction for reinstating the petitioner before the single judge, who is the workman, as a trainee, as was his position on the date of his release by the order that was impugned in the writ proceedings. Next, taking note from the facts as are made out that the petitioner employee was a trainee as on the date of his being discharged from such assignment. The order of the single judge to the operative portion of the order of single judge at para 9 would be stayed subject to the observation that the appellant is to reinstate him in his position as a trainee.
Yes.
All other contentions are kept open.
Very.
Emergent notice to the respondent. The appellants are permitted to serve counsel for the respondent who appeared in the writ proceedings.
I think possibly, my lords, in all fairness, I have to submit there's an IA for delay also. I forgot that
Order
IA
is
for
passed
delay.
pending consideration IA for condonation of delay.
Yes, grateful.
Issue notice on IA as well as mail.
Grateful.
Yes.
Seal number 2. Additional SPP,
Place a week's time to pay the process, my lord, to the
Each
respondent.
time granted to do the needful.
serial number 3. Hema L. Kulkarni,
Prepare for appellant, my lord. During course of the day, I will complain. my lord. During course of the day, I will.
Time granted for necessary compliance.
serial number 4. Shivanand Patil,
Needful done, my lords.
Week's time granted.
Needful done.
Huh?
Needful done.
Counsel for the appellant submits needful is attended to office to verify, and if the process is in order, to issue notice forthwith. Yes,
serial number 5.
Yes.
Manvendra Reddy,
week's time granted for necessary compliance.
serial number 6. SV Deshmukh,
Week's time granted.
Well, two days,
Necessary compliance. Yes.
2 days time, please.
Week's time granted for
If
necessary.
I'm posted on Monday, madam, please. Monday,
Martira?
Monday, madam. Within Monday only.
If the office objections are complied with, relist the matter on Monday.
Please.
Yes.
serial number 7. Vinayak Apte,
Last date application was filed for impleading and notices were ordered to be issued. Notices have been served on the proposed applicants number 1 to 3. So for fourth applicant is concerned, my lord.
First go on the IA.
Oh, sir.
Really,
Sir, sir.
IA for impleading. So we have not yet ordered for notice.
Order, sir.
Agide.
Order na process ಕೊಟ್ಟಿನಿ.
R4 now. R4 is the proposed.
Propose, sir. Proposed party. R1 to R4 are the proposed parties, sir.
R4, 1 to 3 and Agide. So 1 to 3 is served, only 4.
Only 4,
So
sir.
for 4 you have to take
4 is endorsement is unclaimed, sir.
ಆಯ್ತು ಇನ್ನೊಂದು ಸತಿ ತಗೊಬೇಕು. Fresh steps for notice to be issued to R4. Yes, release the matter. Date ಕೊಡಿ March 1st week.
6th of March.
Yes.
serial number 8.
ಅಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅವ್ರದ್ದು ಏನಾದ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ತರಿಸಿದ್ರೆ ತೀರ್ಮಾನನೇ ಮಾಡ್ಬೋದು. After all, it's a succession certificate. If they have no issues,
Issues ಇಲ್ಲ, sir.
ಅಲ್ಲ if they have no difference of opinion, ಅವ್ರನ್ನೇ ನೋಡ್ಬಿಟ್ಟು if
No, in fact, my lord, after filing succession certificate, public notice was issued as provided by law. Nobody objected, nobody appeared and contested. And admittedly, my lord, all service record and other DCSG records, the name of the appellant is shown as nominee.
let us see, in case he doesn't come next time, it could be disposed of.
I will take it, sir. If all are ready, my lord, to give no objection, then I will submit and move the matter. Obvious.
Yes, please.
serial number 8. Basavaraj Kareddy,
For the respond number 2 in the matter, my lords.
Yes.
On last date of hearing, we had entered our appearance, my lords. The honorable court had directed to submit rejoinder, my lords. Because there was a compromise recorded in the record.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕದ.
Huh?
They have to file objection.
You have to file your
Yes, my lords.
stand. In so far as R2.
Yes, my lords.
You file your stand.
Yes, I'll file, my lords, because the review petition is already filed, my lords, before the very same judge where the compromise was recorded, my lords. Because the extent of the,
Anyhow, you file whatever you want to.
yes, I'll file objections, my lords.
Each time granted for R2 to state, to file is counter affidavit.
Please. my lords. Obliged.
ಫೈನಲಿ ಅಂತ ಆಗಲಿ. ಫೈನಲಿ
Huh?
ಫೈನಲಿ ಅಂತ.
Finally.
Please.
Finally.
Please. my lords.
Vivekananda doesn't take time.
No, yes, yes, my lords. I'll file my state.
Yes.
ಇಲ್ಲ ಇದ್ರೆ ಟ್ರಿಕ್ಕಿ ಸಿಚುವೇಶನ್ ದಾಗ ಅದಾರ ಅವರು ಹಿಂಗಾಗಿ. They want to somehow.
Please.
Sanket Appaji, serial number 9.
Appear for the respondent, my lord. I filed the, my lord, affidavit with compliance, my lord. My learned friend has taken time to file the rejoinder to that. But we issued the endorsement also, my lord, that is to the
On submission,
complainant,
my
my
lord.
lord. And saying that, my lord, there
Yes,
is
what do you say?
I am proxy counsel, lordship. Kindly have it on Monday, lordship. Some personal inconvenience of the petition. The complainant is not.
Relist on Tuesday.
Please.
Yes. Now they say they have complied, isn't it?
yes, my lord, compliant.
No days.
ಪ್ರೀವಿಯಸ್ ಡೇಟ್
ಕೊಟ್ಟಿದ್ದಾರೆ. ಡೇಟ್ ಯಾವುದು?
6/3.
60. Yes.
Case number 10, BV Jalde.
Appearing for the complainant. The respondent number 2 has complied the order of the learned single judge.
Learned counsel for the complainant. You file a memo.
They have filed the reply statement saying that they have complied it.
No, correct. You are satisfied. So you file a memo. Learned counsel for the complainant submits that there has been compliance. In light of the said submission, proceedings are dropped.
Number 11, GG Chagashetty.
In this matter, my lord, we comply the direction of the learned single judge. My lord. Madam. There is a direction, my lord, page number 11, my lord. Direct the deputy commissioner to consider the representation dated 30th 8 10 to 17 to 2022 wide annexure so and so.
E1 and E2.
Madam,
To consider E1 and E2.
yes, my lord. That was, my lord, kindly see, my lord, in affidavit, my lord. Annexure R1, my lord, I requested the, my lord, PWD department to submit the report. Page number 2, my lord. Sorry, page number 5, my lord. Annexure R2, my lord. Assistant Commissioner, my lord, a written letter to the, my lord, respondent, my lord, to that notification itself is, my lord, denotified.
Already they have acquired and formed the road mass passing through my land to an extent of 2 acres, 10 guntas. And also they have passed an award. But only thing is they have not paid the amount.
Kindly see my annexure R2, my lord. I will read, my lord, what is the land acquisition officer he says, my lord. Page number 5, my lord.
I can understand, but if the road is not formed, passing through my land,
This is amounts to criminal contempt. No, this is trying to throw mud into the court size. I am taking serious, sir.
No, the endorsement is issued, my lord, annexure R3, my
This
lord.
old road, new road story has been there for centuries. That's a different matter. Once you use some poor person's land, minimum sense of guilt, you must compensate.
But I will read, my lord, I'm leaving to lordship, my lord, because,
we
my
have
lord,
been seeing the same kind of stereotype affidavits.
annexure R3, my
So
lord.
let us have a look at the representation. Let us have a look at what is the representation file. If you have not used, we are the last persons to order for payment of compensation. In 97, you notified it.
Yes.
For acquisition and directed the assistant commissioner to publish 4-1 notification.
Yes. Thereafter, my lord, it is denotified, my lord.
and also award has been passed, my
Huh?
award also passed. Only thing is they have not paid the amount.
The proceedings relating to acquisition, first time.
Yes.
Proposal was sent, isn't
Yes,
it?
my lord.
Why proposal would have been sent if it was old road and you're only
Yes, my
relaying?
That was sent by the PW department, my lord. Then notification was issued. That is not the, not disputed.
So notification will not be issued just mechanically.
Yes, that
You
is
will
true, my
not
lord.
examine, report will be called
Thereafter,
for.
my lord, PW department only requested, my lord, no, that is not required for us. You kೈ ಬಿಡಲ್ಲ ಮಾಡ್ಬೇಕು. But I will read, my lord, endorsement, my lord, para number 3, my lord.
ಇರ್ಬೋದು, but then that throws a big question mark. Why did you initiate the proceedings at the first instance? Some other officer came, he became wiser.
And also they have utilized the land.
That can be
Already they
used
have
by him, my
utilized
lord.
the land.
Where we are not, my lord, that acquired as per the notification, my lord. Thereafter, my lord, is denotified. So that land can be not taken into possession, my lord.
Now the road ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ road ಅಲ್ಲ sir, there is no, my lord, that
They
is
have
the, my
farmed
lord.
the road.
That's why, my lord, kindly see, my lord, for para 3, my lord, for a moment, my lord,
Para
in the
3 of?
endorsement of the deputy commissioner. Annexure R3, my lord. Page number 6, my lord, in the affidavit filed by the deputy commissioner, my lord. ಉಲ್ಲೇಖ 2ರ ಮೂಲಕ ಪ್ರಕರಣ
No, just
ಸಂಖ್ಯೆ.
1 minute. Now, before we go to the endorsement,
Please.
the award was passed in which year?
The year March.
And I think the legal position also, once award is passed, possession is taken. There cannot be, you cannot drop it. And cancellation ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ. After 16 years, no? How we can accept that? ಕೊಡಿ. Possession was taken, isn't it?
Position taken, they have already farmed the road long back.
2004 ಅಲ್ಲಿ.
Instruction is, my lord, award is not passed on. That is the instruction.
ಆಯ್ತು ದುಡ್ಡು 2004 ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಯಾರೋ some very enlightened soul comes there after 16 years. What is the, how state must behave with fairness?
So that is my instruction is, my lord, 4-1 notification was issued, my lord, even 6-1 notification is not issued. Award is also not passed. That is the instruction of the official, my lord.
No, what we are saying now with respect to some extent where you wanted to make a road, you had sent 4-1 notification. Now suppose you have utilized it. And then
It is, my lord, proposed to, my lord, acquire, my lord, 4-1 notification is issued. That's all, my lord. Thereafter, my lord, when final notification is issued, my lord, then it will be, my lord,
no,
positive, my lord.
now you show the sketch, let us see. We'll ask him to enter into possession of that land.
We'll file the, my lord, detailed affidavit of the deputy commissioner, my lord. Whether the, my lord, 6-1 notification is issued or not, my lord, even award is also.
No, we want a sketch of the land proposed to be acquired under the 4-1 notification.
Last, my direct us to, my lord, we'll get the, my lord,
Let the affidavit be filed by Friday.
please. I'll take back, my lord, this.
Now, what, under what ground you denotified? On the ground that?
On the ground that, my lord, PW department only requested, this road is not required.
Not
Whatever,
required.
yes, yes. So that is, my lord.
Where is that? Let us have a
But
look.
Assistant Commissioner, my Annexure R2, my lord, that is kindly, Annexure R2. That is page number 5, my lord.
Yes.
I will read, my lord, only one para, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಫ್ಜಲ್ಪುರ್ ಸರ್ವೆ ನಂಬರ್ ಸೋ ರಲ್ಲಿ ಅಫ್ಜಲ್ಪುರದಿಂದ ದುದಿನಿಗೆ ಹೋಗಲು ರಸ್ತೆ ನಿರ್ಮಾಣಕ್ಕಾಗಿ 2 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಭೂ ಶೋಧನ ಪಡಿಸಿಕೊಳ್ಳುವಂತೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯವರು ಪ್ರಸ್ತಾವವನ್ನು ಸಲ್ಲಿಸಿದ ಪ್ರಯುಕ್ತ ಭೂಸೋಧನೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪ್ರಾರಂಭಿಸಲಾಗಿರುತ್ತದೆ. ಭೂಸೋಧನೆ ಕಾಯ್ದೆ ಕಲಂ 4(1) ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗಿತ್ತು ಹಾಗೂ 5(1)A ವರದಿಯನ್ನು ಮಾನ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಉಲ್ಲೇಖ 3ರ ಮೂಲಕ ಭೂ ಕೋರಿಕೆ ಇಲಾಖೆಯದವರಾದ ಅಭಿಯಂತರು ಕಾರ್ಯನಿರ್ವಾಹಕ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯವರು ಗುಲ್ಬರ್ಗ ಸದರಿ ರಸ್ತೆಯ ಹಳೆಯ ರಸ್ತೆಯಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಈಗಾಗಲೇ ರಸ್ತೆ ಇರುವುದರಿಂದ ಸರ್ಕಾರದ ಹಿತದೃಷ್ಟಿಯಿಂದ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಕೈ ಬಿಡಲು ಕೋರಿರ್ತಾರೆ.
ಜಸ್ಟ್ 4/1/2004 ಅಲ್ಲಿ ಮಾಡಿದ್ರಿ. 25 ಅಲ್ಲಿ ರಸ್ತೆ ಹಳೆ ರಸ್ತೆ ಇದೆ, ಅದರ ಮೇಲೆ ಹೊಸ ರಸ್ತೆ ಆಗಿದೆ. ಯಾರ ಜಮೀನು? ಅವನ್ ಜಮೀನು. ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಟ್ರಾಯ್ ಆಗಿರುತ್ತೆ. ಆಫ್ಟರ್ 25 ನಾಟ್ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಡಿಫ್ರೆಂಟ್. ನೀವು ಅವ್ರ ಜಮೀನು ಉಪಯೋಗಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ರೋಡ್ ಇದೆ ಅಂದ್ರೆ prima facie, I'm saying you're trying to abuse the process legal process.
No vehicle movement in that road, huh?
But that is
No vehicle movement.
no, that time, my lord, that road was there, my lord, existing road, my lord. That is, my lord, there says, my lord, PW department says, my lord, hardly old road, my lord, that is.
Let him take possession. Let him stop the vehicle movement.
That is, my lord, we don't know what is the width was there, my lord, that time, my lord, that has to be.
4/1 ಮಾಡುವಾಗ ಇದೆಲ್ಲ ಗವರ್ಮೆಂಟ್ ಅಷ್ಟು ಸುಲಭವಾಗಿ 4/1 ಮಾಡ್ತಾರ? ದುಡ್ಡು ಹೋಗುತ್ತಂತ ಅಲ್ಲಿ ದುಡ್ಡು ಬೇರೆ ಕಡೆ ಸೋರಿದ್ರು ಇಲ್ಲಿ ಲ್ಯಾಂಡ್ ಓನರ್ದು ಈ ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ದು ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಯುಟಿಲೈಸಿಂಗ್.
First they submitted the proposal, my lord. It is not
So what we are saying, suppose at the first instance when you submitted a proposal, it would be on the basis of some report stating we require that land of the landowner.
Yes.
Without which you would not have moved an inch. So many matters 4/1 you don't pass as a matter of course. So it prima facie puts a question mark.
We'll ascertain that, my lord, what is the actual fact, my lord, then we'll file the affidavit, my lord.
So by inducing the landowner, you acquired the land, you laid the road, it amounts to 4/1, it attracts section 415 of IPC.
Yes, my lord, that is true.
Not the way.
The petitioner had filed a writ petition to seeking consideration of his representation relating to utilizing the petitioner's land for road purpose and to pay compensation in terms of 4/1 notification initiated. Full stop. The said writ petition was disposed of with a direction to the state authorities to consider the representations. Full stop. EGA files a memo, files an affidavit along with the annexures including R2. Perusal of R2 would reveal that notification issued under section 4/1 with respect to the land of the petitioner has now been dropped on the ground that the beneficiary has stated that the old road itself was converted to a new road and hence land of the complainant was not required. Land counsel for the complainant would point out that 4/1 notification was passed in the year 2004 and amount was also released as is evidenced from the proceedings of 27/1/2004. Yes, you place it on record. Copy of which is produced. Taking note that the 4/1 notification was issued in the year 2004. The stand in R2 appears prima facie as an action to deny compensation to the petitioner after having utilized his land. Full stop. Detailed affidavit to be filed as regards the preliminary notification issued at the first instance, which is an admitted fact, along with the relevant sketch and records of the proposed area of acquisition under the section 4.1 notification. Full stop. Such direction is passed in light of the contention of the complainant that the state authorities, after having utilized the petitioner's land, are now seeking to renege their assurance of payment of compensation by taking resort to giving up the acquisition proceedings. Necessary affidavit to be filed by the Deputy Commissioner. Relist on Monday. You please ask the Deputy Commissioner to take this matter seriously. Memo Aki.
Please.
Copy of the order to be furnished forthwith to the AGA.
Well, Harshvardhan R. Malik.
This matter, my lord, we complied the direction of the learned single judge, my lord. We also, my lord, effected the entry.
Order was to consider the representation, it is considered. Lord, an order is passed, my lord, which is partly in my favor, partly, my lord, I am with liberty to, my lord, challenge. My lord, it can be.
Memo along with enclosure submitted by the AGA, and it is submitted that direction for consideration of representation dated 9/11/2023 has been complied with.
Yes, by order dated 27/1/20.
By order dated
27/1/2025.
27/1/2025. In light of the same, proceedings are dropped if the complaint is aggrieved by any portion of the order dated 27/1/2025. Liberty is reserved to take appropriate proceedings. All contentions are kept open.
Great.
I'll take notice for R1, my lord, is served, my
GA,
lord.
GA accepts notice for R1.
Great.
Yes.
Number 13.
ಆಮೇಲೆ ಎಲ್ಲ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಎಫಿಡೇವಿಟ್ ಮಾಡೋದು ಅಭ್ಯಾಸ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು
Now only they produce. They directly they given to my learned friend, my lord, that's why.
ಅಲ್ಲ ಆಯ್ತು ಎಲ್ಲಾದ್ರಲ್ಲೂ ಎಫಿಡೇವಿಟ್ ಹಾಕೋದು ಅಭ್ಯಾಸ ಮಾಡಿಸ್ಬೇಕು.
Definitely, I'll do it.
You can ask an office order to be passed in your office that wherever compliance is reported, one, you have to explain the delay. Two, you have to state on affidavit.
One, my lord, matter, my lord, there is a delay, my lord, absolutely, there is a delay 1 year.
Shall we make an observation? Code of process. No, that's okay. That's okay. ಇದರಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ. ಮೆಮೊ along with the order.
Now, when was the direction passed?
It was, Lord, on 19th March 2024. It was supposed to be considered, my lord, within a period of 3 months, my lord, from 19th March.
On 19th of March.
Yes, my lord. By June 19th, my lord, they were supposed to consider. It's delayed by, my lord, almost 7 months.
Now the order of consideration is
27/1/25.
And to the additional Secretary General Kalaburagi with the direction that the full direction to be given
Chief Secretary
to
will
all matters.
Chief Secretary will
Copy to
update. Chief Secretary.
The complainant has sought for initiation of contempt proceedings and to sentence the accused for contempt of the direction dated 19/3/2024 in WP 20066 of 2024. The petition was filed on 4th January 2025. Next. Peruse the order passed in WP 20066 of 2024 dated 19th March 2024. Government single judge had disposed of the writ petition with the direction to the Assistant Commissioner to consider the representation dated 9/11/2023 in accordance with law within a period of 3 months. Next. EGA has filed a memo dated 28/1/2025 submitting that the order of the learned single judge was complied with and produces a copy of the office order dated 27/1/2025. Next. No doubt counsel for the complainant submits that the order has been partially complied, though certain grievances against the said order would be raised before the appropriate forum, However, it must be noticed that the proceedings of contempt are one essentially between the court and the authority to implement order of this court. Next. Despite the complainant petitioner having stated that the order is partially complied, the court in the present proceedings is required to be satisfied that there has been true compliance of the order. Next. Admittedly, the direction of the learned single judge was on 19th March 2024 with a direction for compliance within a period of 3 months from the said day, that would be 20th of June 2024. Full stop. The order of compliance submitted by the AGA is dated 27/1/2025. Full stop. Apparently, there is a delay of more than 6 months in considering the representation as directed by order of the single judge. Next. Whenever there is a compliance must be not only as regards the direction, but also with regard to the time limit prescribed by the court. Next. Even if it is submitted in the present case that there has been compliance in terms of adherence to the direction and consideration of the representation, fact remains that there is a delay of 6 months in compliance. Next. We find that in many of the matters, compliance is reported by way of a memo. As observed in CCC number so and so, wherein the court took note of compliance being reported by way of a memo and had imposed cost on the accused of rupees 2,500 payable to the Legal Services Authority. We find that in the present case also, a similar circumstance has arisen. Next. We make it clear that henceforth, wherever compliance is being reported, there has to be one, an explanation of the period of delay in compliance. Two, compliance must be reported by way of an affidavit to ensure accountability on the authority and official who reports compliance, as in many matters, the compliance would also be in the form of consideration, which consideration would be a matter for litigation in further litigation. Full stop. In such circumstances, To ensure accountability, every order of compliance is required to be placed before the court by way of an affidavit. Full stop. Copy of this order to be marked to the accused in the present case, comma, to the Chief Secretary, Government of Karnataka, as well as Additional Advocate General in charge of the Kalaburagi bench, to take note of the same and take steps on the administrative side to ensure that the observations are taken note of appropriately. Accordingly, proceedings are dropped. Subject to the above observation, proceedings are dropped.
One copy
Copy
to
of
me
the
also.
order
my lord.
to
One
be
copy
furnished to the government advocate.
One copy to me also, my lord, because
Yes,
I
yes,
will be,
to the government advocate.
please, great.
The liberty part could be reserved.
ಅದು ಹಿಂದಿನ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಿಂದಿನ observation ಇದೆ. ಹೌದು. So that he is not lost.
13, touching amount.
One week of time.
Even if it's by a subsequent addition. Yes.
1 week of time is requested, my lord.
Yes.
1 week of time is requested to compile of.
Granted for filing of. Yeah, 13 weeks time granted to do the needful.
And interim order may kindly be extended.
Interim order earlier grant is extended till the next day.
14, AM Nagara.
Appearing for the appellant. Annexure V and X are, my lord, the document which are.
A2 1 of 24 is allowed, and appellant is dispensed with production of translated copy of annexures for the present. Insofar as objection number 11, learned counsel for the appellant submits that at the time of hearing of the matter, if legible copies are required, same would be filed.
Please.
Then
R1 and R2 are government, my lord. R5 is the main petitioner. He has entered caveat. And R3 is the Jilla Panchayat in the before the learned single judge Mr. Krupasagar Patil has taken a notice. I will take notice on Krupasagar Patil also, my lord. Matter, my lord.
GA accepts notice for respondents
1, 2,
and 2.
4 also.
1, 2 and
4.
4.
3 is Krupasagar Patil.
Krupasagar Patil accepts notice for 3.
5 is already entered caveat, my lords.
You have served on him?
Yes. May be taken up after 2 weeks, my lords.
Relist after 2 weeks.
Number 50, Shravan Kumar Mat.
My lords, I am.
The objection is only with regard to the filing of the English translations of few Kannada documents. Council submission is made that your lordships are aware about.
Insofar as the objection raised regarding translation, furnishing of translated copies of Kannada annexures, same is kept in abeyance for the present.
Great. Lords, this is a case where the appellant and the respondent number 6, they served as the Adhyaksha of the Gram Panchayat. Respondent number 6 was the Adhyaksha previously, and the appellant subsequently has become the Adhyaksha of the Gram Panchayat. This appellant is elected as a member on 30th of December 2020. In the year 2022, a complaint seems to have been filed alleging certain financial irregularities as against the earlier Adhyaksha, the respondent number 6, and also as against the present Adhyaksha, the appellant before your lordships. The major allegation is against the previous Adhyaksha with regard to non-maintaining of certain vouchers and certain records, etc. The misappropriation is only to the tune of 14.47 lakhs approximately as against the respond number 6. So far as the present Adhyaksha, that is the appellant, is concerned, the allegation is that previously the son of the appellant was awarded certain contract, certain work to the, and during the tenure of the appellant's presidentship, vouchers worth rupees 2,48,668 were released in favor of the work done.
No, what is the order you're challenging?
The order, my lords, is an interim order granted by the learned single judge, where I am aggrieved by the rejection of the entire interim order of stay. Only a partial interim order is granted. My lords will come to page number 14A. Interim order is granted only in so far as disqualifying the petitioner for a period of 6 years is concerned. The order impugned in the writ petition is under section 43A as well as under 48(4) of the Panchayat Raj Act, where I am disqualified not only from being the Adhyaksha as also from being the continuing as a member. Now, my lord has granted an interim order so far as the disqualification as a member for the next 6 years.
Let us have a look at that order.
Yes. Page number 31, my lords will see. The operative portion, your lordships will find it at page number 40.
Page number
40. The opponent number 1 is respond number 6. Opponent number 2 is the appellant.
No, but some detailed inquiry is made.
Detailed inquiry is not made, my lords. Your lordship sitting single has held that for the attraction of section 12H of the Panchayat Raj Act, the words used are present continuous and therefore the work should be, there should be a contract in subsistence. Yes.
Paragraph?
Yes. In fact, the operative portion itself, my lords, have clarified that in para 39.
Read.
Accordingly, this court finds that the impugned order dated 6/8/2022 passed in EP number 2 of 21. The election tribunal has placed the correct interpretation as regards the disqualification under section 12H of the Act by holding that it is only a subsisting contract that could lead to a disqualification by reliance on the clarification of the Karnataka State Election Commission. Such interpretation does not call for any interference. The tribunal has held that the tense used in section 12H is present continuous and accordingly has held that there must be an existing contract to act as a disqualification, and such interpretation does not call for interference.
There must be an existing contract.
It must be an existing subsisting contract which will attract a disqualification. This is the case where
That means in case the contract had already
been granted earlier.
That cannot be a ground.
That cannot be a ground. That is also, my lords, the purpose. Your lordships have referred to the mischief rule and the purposive interpretation, how the two act together.
Now, in this case, what is happening?
In this case, my lords, the contract has been given
to the appellant's son.
Appellant's son, approved on 10/5/2020. 2020.
What is the term of office of the appellant?
The appellant's office, my lord, she has been elected as a member on 30th of December 2020. She became an Adhyaksha now in the second term of that
Panchayat. Member, correct. Member on 30/12/2020. And term till?
Term till 2025 December. I am not sure exactly the date, but it will be for a period of 5 years.
Now that contract given to the appellant's son.
That has, my lord, that
included.
There is no mention about conclusion of that. The only allegation against the appellant is not that she had any interest in the work. It is that there was a work which was already concluded. Vouchers of that work were approved during the tenure of the appellant's Adhyaksha.
Correct. We want to know factually Now, the earlier contract, what you are saying
Yes.
was issued on 10/5/2020, whether even the contract had come to an end.
Yes, yes,
by
that
then.
is, the contract, my lord, started in 24/12/2019.
24?
24/12/2019.
What was the nature of work under the contract?
That nothing is, my lord, forthcoming about that.
Correct. We just want to know factually. Can you,
I will.
we can pass over, can you just find out? Factually, I want to know.
Yes, yes.
Whether, what is the nature of the contract and whether it had already come to an end by the term.
It had come to an end. The order impugned, in fact, will say, the order of the authority disqualifying the appellant. Kindly see page number 39.
Yes.
The last but one paragraph deals with the respondent number 6, the earlier Adhyaksha. Then the last paragraph, ಮತ್ತು ಎರಡನೇ ಎದುರುದಾರರು ಶ್ರೀಮತಿ ಈರಮ್ಮ ಗಂಡ ಅಮರಪ್ಪ ಸಾಕಿನ್ ತಡ್ಕಲ್ ಹಿಂದಿನ ಸದಸ್ಯರು ಹಾಗೂ ಹಾಲಿ ಅಧ್ಯಕ್ಷರು ಇವರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಸದಸ್ಯರಾಗಿದ್ದ ಅವಧಿಯಲ್ಲಿ ತಮ್ಮ ಮಗ ಶ್ರೀ ನಾಗರಾಜ್ ಇವರ ಹೆಸರಿನಲ್ಲಿ 2,48,668 ರೂಪಾಯಿಗಳನ್ನು ವಿವಿಧ ಕಾಮಗಾರಿಗಳಿಗೆ ವೌಚರ್ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ 2 ಲಕ್ಷ ಗಳನ್ನು ಪಡೆದು ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮದ 43A(5) ಅನ್ನು ಉಲ್ಲಂಘಿಸಿರುವ ಆರೋಪವು ಸಾಬೀತಾಗಿರುತ್ತದೆ.
Yeah, that one you just clarify factually. That statement will record. Now, in this judgment, have we stated that where here also it was something similar, I think.
Yes, yes.
So
It was
contract
about
was concluded, only payment was due.
Yes, yes.
Just take me to that.
Yes. About the
No, that contract.
Yes, the work in the present case, my lords, in this appeal is about construction of some gutters and supply of manpower for that purpose. And when it has ended also, my lords, I will get the instructions. My lords will see that the interpretation starts from para number 22. In paragraph 15, my lord has noted that the election was notified on the 7th of July 2020. Polling was on 27/12/2020. Counting was on 30th of December 2020. Results were announced on the same day. Payment was made previously on 3/7/2020.
Okay, but here the payment also was already done.
Yes, but your lordships have interpreted, there is no question of, my lords, payment being made. Your lordships have interpreted section 12H to say whether the words here, he has directly or indirectly any share or interest in any work done or order of the Gram Panchayat. This has been interpreted to mean that there must be a subsisting contract as on the date of the membership. Para 22, my lords have said that though the wordings of the said provision makes a subsisting contract a precondition for invoking disqualification,
So if the work was done already.
Yes.
Then there will be no conflict of interest.
There is no conflict of interest.
If the work was done earlier to the present term of office, then technically there cannot be any conflict of interest. Then factually you just tell us that the work done was concluded even before this
now secondly
person took office.
Yes, I will take that instruction, lords, and I will make a submission to that effect also. In fact, my lords, there is one decision of another learned single judge which has not been appealed, where it is held that for the purposes of section 43A, the inquiry should be, my lords, by recording the statements of the inquiry officer also.
That is on principles of natural justice.
Principles, merely issuing a show cause notice and then receiving an objection, which has happened in this case, is not
inquiry.
There is no inquiry as such. Only a notice is issued, reply is then taken on record, and an inquiry officer, my lords, he gives his own report and forwards it to the higher authority, who acts upon that and then passes the order of disqualification. My lords, what has happened is the learned single judge was pleased to grant the interim order so far as the disqualification under 12H is concerned for 6 years. Now, my lords, 43A is one which takes away my right to act as Adhyaksha presently. Now, that is not stayed. So, my lords, I have already overcome the...
Regarding nature of inquiry, any reference?
Yes, ma'am.
In the present case?
Yes, yes. So, Annexure C is the inquiry report. Page, Annexure C, page number 45. The regional
46.
45 is the covering note,
yes,
which shows that the regional commissioner has forwarded his inquiry report to the, yes. And 46, my lords, doesn't, it's only at page number 49, the findings are in one paragraph. 15ನೇ ಹಣಕಾಸು ಯೋಜನೆ ಮಾರ್ಗಸೂಚಿಯನ್ನು ಉಲ್ಲಂಘಿಸಿ ದಾಖಲಾತಿಗಳು ಇಲ್ಲದೆ ಕಾಮಗಾರಿಗಳನ್ನು ನಿರ್ವಹಿಸಿ
When was the work concluded? You
I will. There is one more decision, my lords, which says, in fact, my lords, so far as that work conclusion is concerned, with regard to the allegation which contradicts section 12H, already the interim order is granted. Now, my lords, I am only seeking for intervention in so far as section 43A is concerned.
No, correct. What we are saying, we could extend the interim prayer. We want to know if, as on the date of the petitioner having become a member of the Gram Panchayat, if work was already done previously, we'll record that.
I will take instruction.
Awesome.
Yes.
So far as nature of inquiry, of course.
Yes.
That is that's another part of it. But this, then there will be, suppose work was already done. What remained was only payment. Then maybe we could say that there is technically no conflict. But if the work continued,
yes,
that factually you verify.
Lords, work should continue not only being as a member, but also when she took charge as an adhyaksha. That's the allegation against her.
Correct. But if the work was concluded, there ends the matter.
Yes. Great.
Yes.
Number 60, Sudhir Singh Bijapur.
There is a delay, my lord. Objection has to be filed.
List in the second week of March.
Number 70, Ratna and Yogiman.
In this matter, my lord, appear for the respondent, my lord. We comply the direction of the Lawrence single judge, my lord.
I'm not complied, my lord. Time
Also
and
filed the
again,
affidavit, my lord.
same reason. Krishi Jamin ಆಗಿರುತ್ತೆ. It comes under the agriculture zone, which is already quashed by the
What was the direction?
direction, my lord. Ink page para 8, from para 8, my lord.
Page?
Para 8 of the learner single judge. From para.
Page.
Page 16, my lord.
Para 8.
8. Carried it. On such perusal, the material on record, there is no answer by governmental authority to Annexure K produced by the petitioner in all these petitions by way of additional documents. Annexure K is the order of the Deputy Commissioner dated 29/8/2016, wherein respect of land several survey numbers of Sirnur village, the Deputy Commissioner has granted permission to convert the lands of non-agricultural purposes. In the year 2016, the Deputy Commissioner has granted permission for usage of
Now you made representations.
Yes, my lord.
So
Made
now what they have replied?
Now, my lord, earlier, my lord, they have filed the memo and produced the 15/8 endorsement 15/8/2014. Again, now they have filed the affidavit along with the affidavit producing the
Correct. What is
additional
the reason? Let us have a look at the reason assigned.
reasons in the endorsement. My lord.
Yes,
Now
the-
they have filed today they have the affidavit along with these documents, my lord. The
Page?
affidavit, my lord, today.
Correct. Which page of that
Yes,
affidavit?
yes, my lord. Affidavit.
R4,
R4, first one is the
page 12, R4, Imbaraha.
yes, R
Then,
25/8 2021 is the letter issued by the commissioner to the deputy commissioner. Page 8 ಅಂತ ಅವರದಲ್ಲಿ affidavit ನಲ್ಲಿ.
Correct, but I think the order endorsement is R4.
Endorsement that
R5
is
the order, my lord.
R5.
R5 is the order.
Let us have a
We
look
issued
at
the
R4
endorsement,
is
my
the
lord.
first order, 15/10/24. Then now the R5 is next. Both
what is-
orders. They have issued two orders, man.
Correct. What is the reason that they've given? Let us-
Reason first ದಲ್ಲಿ R4 ದಲ್ಲಿ ಕಂದಾಯ ದಾಖಲೆ ಹಾಗೂ ರಸ್ತೆ ಸಂಪರ್ಕ ಕುರಿತು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿದಲ್ಲಿ ವಾಣಿಜ್ಯ ಉಪ ಉದ್ದೇಶ ಸ್ಪಷ್ಟ ಮಾಹಿತಿ ನೀಡಿದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ವರದಿ ಸಲ್ಲಿಸಲಾಗುವುದೆಂದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ದಟ್ ಈಸ್ ದಿ ರಿಪೋರ್ಟ್ ಗಿವನ್ ಬೈ ದ ಕಮಿಷನರ್. ಪ್ರಯುಕ್ತ ಪ್ರಸ್ತಾಪ ಜಮೀನು ಭೂ ಪರಿವರ್ತಿಸಲು ಹಾಗೂ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕೆ ಸ್ಪಷ್ಟವಾದ ಮಾಹಿತಿ ದಾಖಲೆಯಿಂದ ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ. Already they have submitted online application. Again they have issued one more endorsement R5, my lord. Thereafter, last me kindly see the last para, ಆದೇಶ. ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಕಲಬುರಗಿ ದಾಖಲಾಗಿರುವ ಸೋ ಅಂಡ್ ಸೋ ಆದೇಶದಂತೆ ಕ್ರಮವಹಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಸದರಿ ಅರ್ಜಿ ಈಗಾಗಲೇ ಆನ್ಲೈನ್ ನಲ್ಲಿ ತಿರಸ್ಕೃತವಾಗಿರುವುದರಿಂದ ಮಾನ್ಯ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋರ ಮೂಲಕ ಪ್ರಸ್ತುತ ರಾಜ್ಯದಲ್ಲಿ ಅಫಿಡವಿಟ್ ಪ್ರಮಾಣ ಪತ್ರ ಆಧಾರಿತ ಭೂ ಪರಿವರ್ತನೆ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುತ್ತದೆ. This order is only to file application on online application. They issued special circular. ಅರ್ಜಿದಾರರು ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಕಂದಾಯ ದಾಖಲೆ ಹಾಗೂ ರಸ್ತೆ ಸಂಪರ್ಕ ಕುರಿತ ದಾಖಲೆಯನ್ನು ಸಲ್ಲಿಸಿದಲ್ಲಿ ವಾಣಿಜ್ಯ ಉದ್ದೇಶದಲ್ಲಿ ಉದ್ದೇಶದ
No, but they've kept it open still. They have not rejected it completely. ನಿಯಮನಾಸ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು ಆದೇಶ.
I have to file one more application. Already you have filed application. That first time it was raised, it comes under as agriculture land. Now they have taken different contention that you have to file online application by furnishing those documents.
There are some checklists online in order to prevent any kind of manipulation. It's all being done online process. You follow
Direction is by following that annexure RK. So annexure K. So already the adjacent lands were converted in there 2016 itself.
No, that is treat them
20 acres of land.
I treat them similarly, no doubt. But we don't know what other raste samparka etc. How do we decide?
First the contention is that it is comes on agricultural zone ನಲ್ಲಿ ಬರುತ್ತೆ.
Raste samparka.
ಈಗ now they are taken separate.
ಅದು clarify ಮಾಡಬೇಕು. We can't decide here.
I'll furnish that village map.
But not in contempt proceedings we cannot. We will have to comply with that requirements and they will consider. They have not rejected it outright. The fact that neighboring lands have been done, that's a matter that will weigh in their mind, no doubt.
I can't file one more application. Already you have filed application.
Online, as on now, you have to convert.
ಅರ್ಜಿದಾರ ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ.
That will be deemed to be in continuance of the.
That has to be clarified. That has to continue.
No, that we will say.
Otherwise, I have to file one more application. Then they may raise the queries in the said application.
Okay. Now, you have asked for some further details, etc. They will do it online, but that is to be treated to be in compliance with the earlier.
That is true.
As a continuation of the earlier application.
Yes, ma'am.
Whatever others they have, they'll clarify.
It's true, my lord. Within this stipulated period, my lord, we have to, my lord, to comply the, my lord. Otherwise, my lord, it will be deemed to be, my lord, granted the permission.
Absolutely.
But that is the reason, my lord, we rejected that online application is already rejected. That is, my lord.
On the ground that is ಹೌದು ನೀವು earlier reject ಮಾಡಿದ್ದು ನೋಡಿ ಏನ್ reject ಮಾಡಿದ್ರು.
Annexure R5, my lord, finally see, my lord. That is ಉಲ್ಲೇಖ number 4, my lord. ಈ ಕಾರ್ಯಾಲಯದ ಎಂಬರ ದಿನಾಂಕ 23/9/2023. This is the online application which is rejected by us, my lord. Why it is rejected, my lord? There is no complete, there is no link road particular is not given. That is explained also, my lord. If we submitted all the documents, relevant documents along with the, my lord, documents online, definitely we will consider it.
But but this is subject to one condition, that in your checklist you have maintained one office checklist. whatever earlier has been complied with, they'll give whatever
Yes, yes,
they have done.
yes.
You cannot again
No,
revisit
no, no,
that.
no, we'll not.
Whatever has been complied by them earlier,
Yes,
they will give all the documents that they gave the first time and do it online. However, you must take it from this stage.
yes, ma'am, definitely.
ಇದರಲ್ಲಿ earlier the endorsement, my lord, the said land is reserved for agriculture purpose ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಅದು ಹೋಯ್ತಲ್ಲ.
ಅದು ಹೋಯ್ತು. Again they have in this contempt petition they have issued one more endorsement that it is there is no connecting road ಅಂತ.
ಹೈಕೋರ್ಟ್ ಸ್ಕ್ರೂಟಿನಿ ತರ ಏನ್ ಮಾಡೋದು?
They go on issuing one or the other reason for the endorsement. That is the problem. Now again we have the approach as a single judge. They issued the past order. Again they issued one more endorsement stating that no, you have to comply to this one.
No,
This is the fate of the.
We agree with you that ಆಮೇಲೆ ಇವು ಕರ್ಸ್ಬಿಟ್ಟು ಏನಾದ್ರು ಇದೆಯಾ ಇಲ್ವೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿ ಅಲ್ಲಲ್ಲಿ ಮಾಡ್ಬೇಕು.
That is why, my lord, annexure R3, my lord, we requested the Urban Development Authority.
No.
Earlier also they requested.
There is absolutely no. The grievance is for some people there is a green gate ಅಂತ visa ಅದೇನೋ ಆ ರೀತಿ green gate ತತ್ಕಾಲ್ ಅಷ್ಟೇ ಗೊತ್ತಿದ್ರೆ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಕಣ್ಮುಚ್ಕೊಂಡು ಆಗೋಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ ಅವ್ರ ಗ್ರೀವಾನ್ಸ್. ಹಂಗೆ ನಡೆಯೋದು.
One more request, my lord. ಕಂದಾಯ ದಾಖಲೆ ಅಂದ್ರೆ ಏನಂತ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಇಲ್ಲ. They have to say ಕಂದಾಯ ದಾಖಲೆ. Once is which that.
They have to clarify.
ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಇನ್ನೊಂದು ಕಂದಾಯ ದಾಖಲೆ ಅದೇ ಸೇಮ್ ಹಾಕಿ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಹೈಡ್ ಮಾಡ್ತಾರೆ. which one is ಕಂದಾಯ ದಾಖಲೆ ಹಾಗೂ ಸಂಪರ್ಕ ಕುರಿತು ಅಂತ. ಸಂಪರ್ಕ ಕುರಿತು I can produce this one and let them appoint the commissioner, then they will visit and verify that land.
Now just tell us, we want to clarify that after this she has to file fresh. They have to file fresh application.
Yes, my lord, because that is already closed, my lord.
Okay, but you make it clear that it should be from.
Yes.
And let them say that what is specific, which document is ಕಂದಾಯ ದಾಖಲೆ ಅಂತ.
Yes.
And then I will furnish that ಕಂದಾಯ ದಾಖಲೆ and show that there is a connectivity ಅಂತ.
Please.
The present proceedings have been initiated complaining that the direction of the learned single judge to consider the representations of the petitioners within 15 days was not complied with. Facts are that the complainants had made out representations to consider and pass suitable orders on their application seeking conversion of land from agricultural to non-agricultural purpose. GA filed memo. Once again take it. Mallikarjun.
Sorry.
Memo once again. Once again take it. Memo along with the documents including endorsement. That's filed. Second affidavit.
Yes, ma'am.
It's filed affidavit on 18/2/2025 along with the documents including the order at annexure R5.
Please.
Which reads as follows. It is submitted that accordingly the consideration is complete. Learned counsel for the complaint submits that the petitioners are caught in endless rounds of litigation as the endorsement may amount to only a paper consideration of the representation but not the request of the petitioner for conversion of land. It's further pointed out that the endorsement issued is vague and would lead to further litigation as the stipulation in the endorsement dated 17/2/2025 is that the online application has been rejected in light of the complainant not having furnished revenue documents and documents showing access to road. Full stop. GA submits that the earlier online application has been closed, and the petitioner is to file a fresh application, and needless to state, insofar as such aspects under the old application which were answered and clarifications given, same would not be revisited, and the fresh online application would concentrate as regards the reasons pointed out in the endorsement of 17/2/2025.
Please.
Full stop. It's further submitted that clarifications regarding furnishing of revenue documents and nature of document to be furnished regarding road access would also be made to the petitioner. Taking note of the same, proceedings are dropped.
That the earlier application may be treated.
We have stated whatever compliance is made in the earlier, they will not revisit it.
Yes, my lord, they can't.
That we have stated. Though it is fresh, whatever they are satisfied, don't visit. That what I
Only these two, my lord, let them say specifically which document.
Yes.
And this. It outer limit, otherwise they may. ಅವ್ರು ಕೊಡೋದೆಲ್ಲ ಆಫೀಸಿಗೆ ಹೋದ್ರು ಅವ್ರು ಕೇರ್ ಮಾಡೋದಲ್ಲ ಕ್ಲೈಂಟ್ಸ್ಗೆ.
ಹಾಕಿ
Like, let them specification must be within so and so that
Online
revenue
application,
document.
not online application, we have to do it within the stipulated period of time. If it is not done, that will benefit to her only.
ಅಲ್ಲ,
Deemed conversion.
Deemed conversion, they issued circular, it is contrary to the act, my lord.
ಅಲ್ಲ, if you
ಅದು
not
15 days
considered
ಅಂತಾರೆ, ಅದು act ನಲ್ಲಿ 15 days ಇಲ್ಲ, 120 days ಇದೆ. Contrary to that issued the circulars. Your circular is contrary to the act.
under the circular, what is the time?
15 days time ಅಂತ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. 15 days time, otherwise deemed
Earlier,
ಅಂತ.
my lord, that was
Earlier ಇಲ್ಲ, act ನಲ್ಲಿ 120 days, 95 ದಲ್ಲಿ.
that is benefited to her.
ಅಷ್ಟು efficient
ಅಲ್ಲ, whatever it may benefited or.
ಹೋಗ್ಬೇಡಿ, there will be miscarriage.
ಅದಕ್ಕೆ
ರೀಸನಬಲ್ ಟೈಮ್ ಅಲ್ಲಿ ಎಲ್ಲ ಮಾಗು. ದೆನ್ ಪ್ರತಿ ಸತಿ ಹಿಂಗೆ ಆದ್ರೆ ಎಲ್ಲಿ ಅವರು
ನಾವು ಮಾಡ್ತೀವಿ ಇಮಿಡಿಯೇಟ್ಲಿ.
Correct,
ನೀವು
but
ಮಾಡಿದ್ರೆ
you have
ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಅವ್ರ ಕೋರ್ಟ್.
to look into the circular. 15 days nothing, they can't, you won't ask them to clarify or reject ಮಾಡ್ತೀರಾ ಪ್ರತಿ.
After getting all the documents only, they will submit, my lord.
One submission, let them specification on the 10 days nam kotre, I will furnish those documents. Otherwise, I have to run here and there, that is the problem. They want to open their file and eyes also. Clarification and on the 10 days or 1 week.
Within 10 days, my lord, we will issue which is the documents is required, my lord.
Yes, my lord, that.
GA submits that in terms of the endorsement dated
15.
So and so, the clarification as observed above would be furnished to the
17/2, 17/2/25.
17/2/25.
Yes.
Yes, next, please.
Sir, 18, Ratna and Shivyogi.
Same, both are same endorsement, same affidavit.
Same, my lord, another land, my lord.
Identical order.
Same,
Identical.
everything is
Same affidavit, same, everything is same.
Endorsement is also same.
Endorsement is also same. Same endorsement, ಎರಡಕ್ಕೂ same, ಅದು ಹೆಂಗ್ ಆಗ್ತಾವ ಅವ್ರಿಗೆ, they have to explain it. Endorsement, same reasons. Let me kindly see their affidavit and endorsement.
Same order.
Same order, endorsement to connectivity ಇಲ್ಲ, ಅದು ಹಾಕಿರ್ಬೋದು.
Was a, my lord, common order, my lord. Common order was passed by the learned single judge, my lord, 2 writ petitions.
ಅಲ್ಲ, 2 writs, lands are different.
Same area, adjacent, my lord. Same area.
Same order. The endorsement date matra change, the date same.
Same day, endorsement date to same. Your cyclostyle ಮಾಡಿರ್ತಾರೆ ಅವ್ರ ಸೈಡ್.
19, Sparsha Shetty.
I'm for the appellants, my lords.
For respondent 4 and 5, notes, I request for 2 days accommodation, notes.
IA for dispensation is allowed. Appellant is dispensed with production of translated copies of Kannada annexures for the present. Now, they want some time. Notice must go on.
ನೋಟಿಸ್
IA
ಹೋಗಿದೆ
for
ಸ್ವಾಮಿ, ಅವರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ದಸ್ತಿ ಸರ್ವಿಸ್ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ ಕೋರ್ಟ್ ಸಮನ್ಸ್ ಡೆಲಿವರಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
Let us see the respondent. Kavita wants time. We'll grant some time. We'll see on the next day. Relist the matter in the first week of March.
Much obliged.
Please screen leave.
And for the respondent.
I appear for the. On last date, Lordship, I directed what are the objections you wanted to file before the single judge?
Furnish them a copy.
I'll furnish.
Copy. I don't have any litigation with other persons with regard to this entry. I am worried more about the objection taken by the corporation. Your Lordship may kindly see.
Now, what happened in that other matter you were called to explain?
Adjournment.
It was simply adjourned, my lord, on 7th of March. My lord, here, my lord, they have not
Use the mic.
They have not produced any title deeds to enter their name in the
No,
Khata.
you first take us through the single judge's order.
Please, my lord. Lord, page number 10. Page number 10.
Yes.
I'll start from the first para number 2 itself, my lord.
Mic check.
It's working, my lord.
Yes.
My lord, para 9 is the order starts. The limited grievance of the petitioner is in the present writ petition is that the representation at annexure H, J and J1 dated 17/11/21 and 1/8/24 seeking entering
You're
the
reading at page?
My lord, from page 9 last oral orders. What is the main grievance? Page 9. The order of the learned single judge.
Correct.
8 is the.
Yes.
My lord, the limited grievance of the petitioners in the writ petition is that the representation at annexure H, J and J1 dated 17/11/21 and 1/8/2024 seeking entering the name of the petitioners to be entered in the mutation register and for a direction to issue khata in the names of the petitioners in respect of the subject property bearing CTS number 1432 has not been considered and the respondent has not taken any steps in this regard so far and as such the petitioners are before this court by way of the present writ petition. Now, my lord, the learned counsel for the respondent submits that if reasonable time is granted, the respondent would consider and pass appropriate orders pursuant to the representation of the petitioner subject to verification of records.
Now take us through the writ petition prayer. Let us have it.
My lord, writ petition prayer is at page number 36. 36. Issue a writ in the nature of mandamus or any other appropriate writ direction directing the respondent to consider the representations under annexure H, J and J1 dated so and so and further direct to enter the name of the petitioners in the mutation register and further direct to issue khata in the name of the petitioner in respect of property bearing CTS number so and so.
Yes,
my lord. My lord, the learned single judge, my lord, at
further continue the
please
order.
A pursuit of the material on record comprising of annexure A, khata extract, annexure B, survey records, annexure C, judgment in OS number so and so, judgment in so and so, annexure D, order of the appellate court, annexure E, Yatri Nivas agreement, annexure F, judgment in RA number 1/2020 and annexure G, judgment passed in RSA 200162 of 23 dated 16/6/2023 would indicate that this court has come to the conclusion that the petitioners were the owners in possession and enjoyment of the subject property as held by this court in the said judgment as under. It may also be pertinent to state here that the plaintiff had in fact filed another suit in OS number 476 of 1985 against the corporation seeking for a decree of injunction to restrain the corporation from constructing latrines upon any portion of the plaintiff's property CTS number 1431 and 1432 and also the adjoining space situate at Brahmpur, Kalaburagi. and the space lying towards north of plaintiff's building bearing number 10-653. In this suit, the plaintiff contended that he was the owner of possession of the land bearing survey number 25, CTS number 1431, and open space bearing CTS number 1431, and open space bearing CTS number 1432, bearing municipal number 10-653. In the judgment, which is produced at an Exhibit P10, it is recorded by the trial court as follows. In response to the service of the summons, the defendant appeared before the court through its learned counsel, submitted the written statement under Order 8 Rule 1 of CPC, stating that the plaintiff is the owner and possessor of land bearing survey number 25, bearing CTS number 1431, and open site bearing CTS number 1432. 1432 and building bearing municipal number, all situated at Brahmpur, Gulbarga, is not disputed. My lord, here I'd like to make a pause, my lord. We have only admitted the ownership only in respect of CTS number 1431, not 1432. That I will enlighten, my lord, in the judgment, where in our written statement we have denied. My lord, further, if lordship permits, I make.
Whether that you have challenged that.
No, but I'll just read that para, my lord, in judgment number 476. If lordship looks at page number 67, the WS 476, page 67, para 3.
Yes.
In response to the service of summons, the defendant appeared before the court through its learned counsel and submitted the written statement under Order 8 Rule 1 of CPC, stating that the plaintiff is the owner and possessor of the land bearing survey number CTS number 1431 and open site bearing number and building bearing all situated at Brahmpur is not disputed. It is further admitted. It is in. Sorry, my lord, I'd like to take the lordship at page number 86. Para 3, page 86, para 3. In response to the service of summons, the defendant appeared before the court through its learned counsel and submitted its written statement under Order 8 Rule 1 of CPC, stating that the plaintiff be put to strict proof about the ownership and possession of the open space bearing CTS number 1432. Because by getting CTS survey number to a land belonging to the government, no one will get the rights of ownership or possession in respect of Jatra Maidan. It is admitted here we have disputed the title of the petition appellants, respondents, my lord, in this case.
What my learned friend read at page 67 pertains to suit OS number 476. What my learned friend is now reading at page 86, it pertains to OS number 462 of 85.
But both the suits are for bare injunction, my lord, no declaration. Further, I may read, my lord, para 27, page 12, para.
Who are parties?
My lord, parties is only corporation and the government is not a party. It is only the respondent and appellants, my lord. But where the RSA, which the learned single judge has relied on, my lord, I am not the party to the RSA, my lord. I'll read, my lord. In RSA, I am not a party. If lordship permits me, the relevant portion is at page 14, para 4.
Page
14, para 4 of the learned single judge order, my lord. It is also an undisputed fact that the petitioners herein were arrayed as respondent in the RSA number 200162 of 23, and their right, title, interest, and possession over the subject properties have been upheld by this court, and the same has attained finality and become conclusive and binding upon the respondent corporation. My lord, if I take your lordship to the RSA judgment, which is at page number 92, my lord. I am not a party to the RSA proceedings, my lord. It is only a suit for bare eviction. Page 122.
This is
Yes, my lord. Corporation is not a party to this, and this order is already challenged before the Honorable Apex Court, and it is still pending, my lord. This order is challenged before the Apex Court.
pending.
Yes, my lord. It is pending in SLP, where the other side has also appeared, my lord. This is a suit for bare eviction, and the corporation has nothing to do with this suit, my lord. I am not a party to this suit. The learned single judge holds, my lord, that the respondent is the party to, the corporation is the party to this RSA, and the decree is passed against the corporation. Hence, the title is with the
Now, what is your objections? What is the proposed objection that you
my
have
lord, proposed objection. I'd just read once, my lord.
filed?
My lord, my first, I may start reading it, my lord.
It was disposed of on the first day.
Yes, my lord. Disposed of on the first day. If lordship permits, I may read, my lord, the objections.
And why do you take objection? I mean, it was disposed of on the first day.
First day, my lord.
But did you seek for time?
My lord,
Did you seek for time?
my lord, to say it, truly, my lord, on the very same day itself, the order was not, only it was said allowed, not a positive order was not given, my lord. But once the order was released, it was a positive order. We had only said if considered accordance with law.
Kind of order should not be passed.
In accordance with law, we will say, my lord.
Whatever you may say, it is wrong to say allowed will dictate the order. What do the parties know what is going to come? There is a difference in saying you're going to reserve it. Suppose you have heard both sides, you reserve it. Then it's the prerogative of the court to give reasons. Now, simply if you say allowed, what is this? Now, if both the parties are there, whatever they have, they can put it forward to you. You just look at it. Why this litigation has happened? Because there is something they're saying there was no clarity.
Problem is, my lord,
But did you seek for time? We want to know clearly from you. Did you seek for time on the first day?
my lord, three matters were posted on the very same day. This was for a writ of mandamus. My submission was it will be considered in accordance with law, but it was the learned single judge passed an order saying that writ petition is allowed. But once the order came, my lord, it was a positive direction. It was a positive direction. Because RSA, I am not a party. Three matters were filed, two were adjourned. One, this was only in respect of mandamus for considering the representations. Representations would be considered in accordance with law.
My lord, may I make submission? Lords? On that day, my lord, I am the counsel appearing for the petitioner along with my friend. It is open court dictation,
No, my
not
lord.
reserved and not allowed.
Not this positive direction was not given, my lord. That let him clarify it whether a positive direction was given. Let him clarify it, my lord. There was no any positive direction.
Dictation is given, my lord. Not simply allowed ಅಂತ ಹೇಳಿಲ್ಲ.
Let him clarify whether positive direction was
And
given. Let him say,
one other aspect, my lord, even now, even after a direction by your lordships, my learned friend for the corporation has not filed objections to the writ petition. If at all he has any objection, he now says this order is wrong. I'm not party in RSA. Let him let
my
him
objection
put
is
in
different.
writing what is his objections to the writ petition.
I have filed it to the
It's a
writ
very
petition itself.
strange way of dealing with the things.
No, but if the public authority seeks for some time, you must give them an opportunity.
I'm making this submission very consciously, my lord, because it is not that corporation is fighting this litigation. Corporation is being set up to fight. Your lordship may kindly see for a moment All that I will
Let
point
him
out
file-
is this.
Let them file the proposed objections to the writ petition.
I have filed it today, my lord. Yes,
To
I
the
filed
writ
it.
petition. To the writ petition you file.
Please.
Though objections have been filed. Objections are in the nature of objections to
Comment
the
on the
order.
written order.
Order passed. However, the appellant, in order to enable understanding the nature of objections of the appellant
Lord, this,
to the writ petition, appellant to file and appreciate the contentions of the appellant, it would be necessary to know it's necessary for the appellant to place proposed objections to the writ petition before this court by the next date. Relist the matter. When you will file?
Lord, at least 2 weeks required, my lord. It may be taken part while furnished, my lord. It may be taken up as parted, my lord.
No partner. Relist the matter in the first week of March, date. Interim order earlier granted is extended till the next date. 7th of March.
Please.
7.
Instead of 7th, my lord, it may be taken up Monday.
8th.
My lord,
10th.
the submission, my lord, till then, let them not precipitate the writ petition because there they make certain allegations against me, my lord. Then
Extended the interim order here.
ಅಲ್ಲ ಅಲ್ಲಿ ರಿಟ್ ಪಟಿಷನ್ ಅಲ್ಲಿ ಹೋಗಿ ಇಲ್ಲಿ ನಾವು ಏನ್ ಹೇಳಿರ್ತೀವಿ ಅದು ಅಲ್ಲಿ ದೇ ಮೇಕ್ ಅ ಸಬ್ಮಿಷನ್ ದಟ್ ವಿಲ್ ಬಿ ದಿ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ us.
It is not in our control.
Because only because of last time the order sheet was produced before the learned single such thing happened.
Yes.
To say the least, my lord, they don't even produce the order passed by the survey authorities rejecting the appeal filed by the corporation, which was part of the writ petition. They don't produce it. I would very reluctantly, I am using the word, without producing that order, they got an interim order. If that order was produced along with the writ appeal paper, interim order would not have been granted. Intentionally, that document is not produced.
Yes.
Number 21, M.A. Jagirdar.
This matter, I am filing the objection to the IAM, my lord.
My lord, the conviction is passed against the petitioner as petitioner is accused number 6 in special case number 89 of 2022. The offense alleged against the petitioner is under section 302 and 149 of IPC. My lord, the main allegation against the petitioner is that the petitioner is having illicit relationship with the deceased Satish, and thereby she has the first version of the prosecution case that she was standing with the deceased. At that time, remaining accused went there and assaulted the deceased and committed his murder. My lord, the second version is that accused number 6, this petitioner invited the remaining accused to make a conspiracy to commit the murder of the deceased. And she has instructed all the accused, the remaining accused, that
She had affair with the deceased or accused number 1? This A6 had
Yes.
affair with.
A6, the allegation against A6 that
This appellant is accused number 6. Alva.
6, my lord.
She had an affair with the accused number 1.
Deceased, my lord.
Deceased.
Yes, my lord. And first version of the prosecution case is that in the complaint, this petitioner was standing with the deceased in a lane as accused by the complaint.
She called the other accused to take away the deceased.
She has not invited, my lord. The fact is whether she had got illicit relationship with the deceased or not. This is not proved by the prosecution for the reason that the witnesses who were examined by the prosecution, they have not.
Tell us the allegation against this appellant.
Yes, that is all.
What is it?
The allegation against the appellant in the complaint that on the date of alleged incident, she was standing with the deceased. And by seeing this, remaining accused went there and assaulted the deceased, and thereby he was succumbed to death on the same night itself. The second, further statement is lodged by PW1 that the accused number 6, this petitioner, at 11 p.m. invited remaining accused to come to the spot so that the deceased is causing much trouble, as she was not interested to proceed the illicit relationship with the deceased. Even then the deceased is proceeding, thereby you have to finish the deceased. And after the conspiracy, they went to the spot, and deceased was also there, and all of the accused number 1 to 5, 2 to 5, they have committed the murder of the deceased, my lord. Whereas the only allegation against the accused is MO1 was the chappals were left by the accused on the spot, and MO1 is marked by the concerned court, wherein it is the allegation of the prosecution itself that MO1, the chappals were sent for DNA test, and wherein the report is submitted in exhibit P30, P40, 41 and 42, my lord. Wherein it is said that the chappals are not concerned to the accused. The another important aspect to be considered is on very next day the accused were arrested by the concerned police, and the spot where the offense said to have been committed, it is not shown, and in the presence of the accused, including this petitioner, the spot panchanama was not conducted, and nowhere the spot panchanama, the seizure of MO1 of this petitioner said to have been is also not conducted, and the panchanama relating to the conspiracy, where the conspiracy is said to have been taken place, that panchanama is also not conducted, my lord.
So this appellant also convicted for 302.
Yes, my lord.
What is the role of 201? Why 201 charge invoked for section 301?
They tried to destroy the evidence. Yeah, the allegation is it is not against the accused number 6, my lord. The general allegation is that they tried to destroy the evidence of the prosecution. So far as the offense is taken place on 20th 8, and on 21 8, these all accused were arrested, my lord. So the question of destroying or disappearing of the
The attempt made by them?
attempt made by this, as per the prosecution case, nowhere the allegation against this petitioner.
ಏನಾಯ್ತಂತ ಹೇಳಿ ಮತ್ತೆ ನೋಡೋಣ.
All of them were to the spot, and out of them accused number 2 and 3, they assaulted the deceased by putting a stone over the face of the deceased, and one accused number 4, he was holding the neck of the deceased.
After committing the murder, then they thrown the dead body. Where?
And the dead body was there on the spot itself,
Then why 201 invoked?
It is not known, sir, because in the evidence also it has not come, and nowhere in the prosecution case papers destroying of the evidence of the prosecution itself is not there, because the seizure as per the prosecution, the stone was seized, the sleepers chappals were seized, the mobile also seized, my lord.
Yes, PW2 and 3 are the eyewitness to the incident.
Yes, my lord.
Huh? So seen the incident, then where is the question of 201? Destroying evidence early there. And what is the role of this applicant, appellant?
Appellant was having illicit relation with the deceased, my lord. On motive to the incident is that, my lord. The where the incident was occurred, offense was occurred, she was present on the spot, and she, as per the prosecution, my lord, they, as per the conspiracy theory, they called these accused to
Have you placed
finish.
any call register, CDR? She informed the other accused Ranta.
Yes, to
CDR idea. Call detail register hakidiri. Have you marked any CDR call detail register? Huh?
No, they are not seized mobile itself.
Hmm?
The mobile of the accused who said to have informed the deceased to come on the spot. That mobile and the mobile
Only
number
allegation
itself
against
is
this
not
appellant
seized.
that she informed the other accused Ranta.
Accused
She invited.
She was present on the spot where the offense was occurred, my lord.
He was in the house, and as per the prosecution, he was invited by this petitioner to the spot.
Order on IA number 1 of IA number 144. This application filed under section 389 of CRPC seeking suspension and grant of bail. Full stop. The applicant is the appellant in the main appeal, and she has challenged the judgment and judgment of conviction and order of sentence passed in special case bracket alias CST number 89 of 2022 dated 28/10/2024 by the second additional session judge and special judge at Kalaburagi, whereby the learned special judge has convicted the accused appellant along with the other accused for the offense punishable under section 302 section 143, 147, 148, 302, 120B, 201, read with section 149 of IPC, and sentenced the appellant to undergo life imprisonment for the major offense 302 of IPC. Full stop. The summary of the prosecution case is that the brother of the deceased in this case, one Sabanna, lodged a complaint. That is a complaint on 28/2022 before the respondent police for the homicidal death of his brother Satish, bracket, deceased in this case by the accused, full stop. It is alleged in the complaint that the deceased had illicit affair with this appellant, accused number 6 and accused number 6, full stop. As such, accused number 6, full stop. Though he insisted him not to trouble her, he continued his relationship. As such, the colluding with the accused number 2 to 5 and the boy and accused number 1, the child in conflict, they hatched a conspiracy to do away the life of deceased. Accordingly, on the date or accordingly on 28/2022, accused number 228 along with the child in conflict, committed the murder of deceased Satish. Hence, an FIR registered and subsequently, the investigation officer PW 18 laid the charge sheet against these accused for the aforementioned offences. Full stop. After the aforementioned offences, and also under the provisions of SC/ST bracket LPA Act 1989. Full stop. After a detailed trial, by the special judge in SC number 89 of 2022, the appellant and accused number 2 to 5 were convicted and sentenced as stated supra. Full stop. We have heard the learned counsel for the appellant, so also the learned SJGP, learned SJGP for the state. Full stop. The primary contention of the learned counsel for the appellant that as per the prosecution case, the specific prosecution case, the specific overtact alleged against this appellant that she was present on the scene of occurrence at the time of incident, and she invited the accused number 2 to 5 to the said spot. Full stop. However, the prosecution failed to place any such call CDR, call detail registers, to substantiate the said aspect. Full stop. Further, it's the admitted case of prosecution that the accused number 2 to 5 assaulted the deceased, and 2 to 5 assaulted the deceased and committed and responsible for the homicidal death of deceased. Full stop. The PW 2 and 3, the eyewitness also stated similarly. Full stop. In such circumstance, the learned session judge erred while convicting this appellant for the charges leveled against her. Full stop. Accordingly, prays to allow the IA1 of 24 by suspending the sentence. Per contra, the learned SCGP would contend that the participation of this applicant in the alleged incident clearly proved by the prosecution by placing the evidence of the material witness PW 2 and 3 who are the eyewitness to the incident. So also the evidence of PW 1. Full stop. PW 1. Further, the reason behind the commission of the crime by accused number 2 to 4 is that this appellant had an FIR with the deceased. Full stop. And she only instigated the other accused to do away with the life of deceased. Full stop. In such circumstance, the learned session judge rightly convicted the appellant for the charges leveled against her. Accordingly, he prays to dismiss the application. Full stop. As could be seen from record, full stop. We have carefully perused the impugned judgment and impugned judgment passed by the trial court. Full stop. By the session court. Full stop. On perusal of the same, it could be seen the overtact alleged against this appellant is that she called the accused number 2. Since she had an affair with the accused number deceased in this case, and though she requested him not to continue such, not to indulge such activity, however, he continued the same by insisting her. In such a circumstance, she conspired with along with the accused number 2 to 5, and on the date of incident, she called the accused 2 to 5 and thereby facilitated them to commit the murder of deceased. Full stop. Murder of deceased. However, as rightly contended by the learned counsel for the appellant, there is no such call detail registers are placed by the prosecution. Be that as it may, without expressing any opinion on the merits of the case, suffice to hold that whether he was in custody or.
Yes, she is in custody, ma'am.
She is from throughout the trial.
Yes, she was on bail at the time of trial.
Taking into consider the aspect that the appellant being a woman, she was on bail during the course of trial, and there is no such complaint of misusing the liberty granted to her at the time of trial, and also considering the aspect that this appeal is of the year 2024, and there is no such possibility of hearing this appeal immediately near future, as relying on the law laid down by the Honorable Apex Court in the case of Kashmir Singh versus State of Punjab, reported in 1977, we are of the considered view that the IA-1 of 2024 deserves to be allowed accordingly, allowed with the condition. Accordingly, IA-1 of 24 is allowed, subject to the condition that the appellate shall execute a bond for a sum of rupees 1 lakh with one surety for the like sum to the satisfaction of the session court. She shall deposit the entire fine amount before the trial court.
There's a fine amount exempt ಮಾಡಿದ್ದಾರೆ. ಲೀಗಲ್ ಏಡ್ ಅಥಾರಿಟಿಯಿಂದ ರಿಕವರ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಇವರಿಗೆ ಫೈನ್ ಅಮೌಂಟ್ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಫೈನ್ ಅಮೌಂಟ್ ಮಾಡಿದ್ರೆ ಅದನ್ನೇ ಲೀಗಲ್ ಏಡ್ ದಿಂದ ರಿಕವರ್ ಮಾಡ್ಬೇಕು.
ಆಯ್ತು, ಅಷ್ಟೇ. ಅದು ಬೇಕು. Heard, admit. Registry is directed to secure the TC. Trial bandida. Registry is directed to prepare the paperwork and list this appeal in the usual course. For here.
Number 22, Arun Kumar Amaragundappa.
I appear for appellant. This appeal is directed against the judgment and decree passed by original court, allowing the petition filed by respondent husband, dissolving the marriage of him with the appellant. My Lord, petition was filed before the trial court under section 13(1) and 13(1)(a), seeking dissolution of marriage on the ground of mental cruelty and desertion. My Lord, before stepping into the submissions, main submissions, my focus is on, my Lord, my attack on the impugned judgment is based on, my Lord, number 1, without filing section 9 petition, seeking restitution of conjugal rights, by making vague and baseless allegations, he filed petition seeking dissolution of marriage, number 1. Number 2, my Lord, no independent witnesses to prove allegation of mental cruelty and, my Lord, desertion. Those circumstances exist, so was not examined. And number 3, my Lord, trial court ought not to have.
Passover will take it.
Please.
Now the petition came to be allowed on.
Please.
17 to 20. Be allowed.
Yes, yes.
On
granting. On the ground of, my Lord, mental.
17 to 24.
On? No,
17.
No. On what ground?
On the ground of desertion.
Cruelty and desertion.
Desertion.
No, no, both.
Both.
They're staying apart.
They're staying apart from. Lords, this matter wherein your lordships have also several benches have called in the even the.
All that is blanked out. We come every day.
And now your lordships finally, before your lordships finally, both are directed to file an affidavit, disclosing the assets and liabilities.
That is so far the maintenance.
That is for the maintenance. And also we are directed to file the synopsis, and we have filed the synopsis on 29/24.
So it's on desertion and cruelty.
Cruelty, both.
Now they are staying apart 2 years prior to the petition.
How? No. How? According to us. How? According to us, no.
That is proved by.
That's disputed, is it?
Yes, I am disputing, my Lord. There is materials also during the pregnancy period, my Lord. Very husband has treated her. There is evidence also to that effect.
After the delivery of the baby, my lords, the all this, the only one submission is that, my lords, all that apart, everything, because even I also I tried to convince, because he is a pediatric doctor, my lords, and he is matured enough to understand the things. Yeah. Only the main, what he says is the filing of several criminal cases and assault made by his the brother in the open place. These are the some issues, my lords, which he,
On record.
how the crime or marked, the documents were marked. Total 38 documents were marked. That is one of the FIR is
Is
also
all
marked.
subsequent to, my lord, filing of
These are the
MC
things, my
petition.
lords, which he is not in a position. And thereafter also there is a one issue which is seriously happened, that the daughter, as my lords, the sister of the respondent, they tried to engage with someone. There were some issues, my lord, these persons were also made allegations to them that marriage is also cancelled. And these are the some things, my lords.
What happened to the complaint file?
Complaint charge sheet is filed, and thereafter there was a media, trial was conducted, and against them also the filed a defamation case. Now the court has taken the cognizance. There were serious allegations were made in the before the media against the family members and against him.
All that is a part of record.
How?
It is part of record, my lord, but there are no pleadings to that effect. It is all subsequent.
That's all that circumstances were brought, my lords, to show that there were.
Pass over,
please.
Lord, in this case, my lord, need to produce certain documents, my lord. Serial number 23.
23.
Yes.
Relist the matter.
5th, my lord.
Huh?
5th, 4th or 5th March.
On 5th
Please.
of March.
Number 24, Krupa Sagar Pat.
This is the yesterday's matter, my lord. KB, compassion appointment.
You just take me through the relevant facts.
Please, my
I'll
lord.
dictate.
The father of the petitioners, the father of the petition number 2 to 3, 4 was working as a D group employee in the JESCOM, my lord.
You read the order of the single judge in its entirety.
My lord, please, my lord, I'll read it.
That may bring out everything.
Please, my lord. My lord, page 13, para 1.
Yes.
The petitioner is before this court seeking for a certiorari to quash the endorsement dated 16/5/2013 issued by the first respondent, rejecting the application of petition number 4 for appointment on compassionate basis, as also for a writ of mandamus to consider the application filed representation made by the petition number 4 for appointment. It is stated that one Basoraj, who was working with the respondent, expired on 2/1/2005, leaving behind petition number 1 wife, petition number 2 and 3 daughters, and petition number 4 son as dependents. Upon the death of said Basoraj, the petition number 1 wife made a representation to the respondents on 17/6/2005, seeking for appointment of petition number 4 on compassionate basis after he attains the age of majority. It is further stated that petition number 4, having attained the majority, a representation was made on 16/8/2008, seeking for his appointment on compassionate ground. However, this application was contended to be rejected on 16/5/2013, which is challenged herein.
Now on 16/5/2013.
Yes, my lord.
What was rejected was the application in 2012.
12, my lord. 12. Yes, my lord.
Yes.
Shri P. Vilas Kumar, learned counsel for the petitioners, would submit that there is no dispute as regard the said Basoraj having served the respondents and that he expired on 2/1/2005. Therefore, it was required upon his death that the application filed by his dependents for appointment on compassionate ground ought to have been considered compassionately. He further submits that though petitioner number 1 submitted a representation on 17/6/2005 acknowledged by the respondents, the petitioner did not receive any reply thereto. Thus, the petition number 4, on attaining majority, an application was filed on 16/8/2008, which was also rejected on 16/5/2013. Immediately on receiving the endorsement dated 16/5/2013, the petitioner approached this court by filing the above petition on 25/7/2014. There is no delay on account of the petitioners. It is the respondent who have delayed the matter and not provided the employment to the petitioner number 4. As regards the Karnataka Electricity Board employees recruitment appointment on compassionate ground regulation 1997, hereinafter referred to as the regulation, he submits that though there is a provision made thereunder that an application for appointment on compassionate ground is to be made within 1 year from the date of death of the employee and within 1 year of the application attaining majority. The said provision is only directly and not mandatory. The said Rule 5 is hereunder produced for easy reference. Lord, application for every dependent of a deceased board employee seeking appointment under this regulation shall make an application along with all statutory supporting records, documents within 1 year from the date of the board employee in such form as may be notified by the board from time to time to the head of the office under whom the deceased board employee was working, provided that in case of a minor, application shall be made within a period of 1 year after attaining majority. In this regard, he relies upon writ petition number so and so, more particularly paragraph number 8 thereof, which is produced herein for easy reference. A parcel of the judgment of this court reported so and so would clearly indicate that the period of limitation prescribed is not a mandatory prescription so as to enable and entitle the respondent to summarily reject the application which are belated without examining the nature and extent of delay and the sufficiency of the cause shown. The authorities are held to possess the power to condone the delay and examine the matter on merits so as to find out the penurious conditions and the financial distress in which the family may still be reeling on account of the death of the breadwinner of the family. Relying upon the same, he submits that the said 1 year being directory and not mandatory, the application filed by the petition number 4 on 16/8/2008, though 3 years after the death of said Basaraj, who filed within 1 year after petition number 4 attained majority, ought to have been considered without such consideration being made within a reasonable time. The order passed rejecting the application dated 16/8/2008 is required to be quashed. Per contrast, in Nagaraj Patil, learned counsel appearing for respondents would submit that though an application dated 17/6/2005, though filed by the petition number 1, seeking for reservation of the job for petition number 4 was issued, there was no need for respondent to reply to the same, since application would have to be considered only on petition number 4 making such an application. The petition number 4 made an application only on 26/10/2012. There is no application dated 16/8/2008 received by the respondents. On application being received on 26/10/2012, the same was processed, inquiry was conducted and replied on 16/5/2013. Therefore, there is no delay in the said reply. In terms of the aforesaid regulation, the application has to be made well within 1 year after attaining majority. The date of birth of the petition number 4 is stated to be 12/6/1990. As on the date of the application, he was aged 22 years. That is, application was filed 4 years after attaining majority, and as per the regulation, more particularly clause number 5, as also in terms of the notification dated 25/5/2011, when the Gazette notification was amended, the petitioner would not be entitled for consideration. The said amendment is here reproduced for reference. Lord, amendment was carried out, my lord. Prior to the amendment, it was 1 year from the date of attaining majority. After amendment, it is from the date of death of the concerned officer within 1 year, my lord.
Amendment was in which year?
My lord, amendment was carried out in the year 2011, my lord, 25/5/2011. Here there is no dispute, my lord. He has to make an application within 1 year from the date of attaining majority. As per the old rules, yes, because as on the date of death, that was the
rule in existence.
Yes, my lord. If we go to the amended notification, then his application itself will not be maintained because he has to file an application within 1 year from the date of the death of.
Even in terms of the old rule, he has not filed.
Yes, my lord. Even under old rule or new rule, both, my lord. Under old rule, within 1 year, he has to attain majority, my lord. But under the new